Welcome to episode 12 Probate Reviving Your Deceased Accounts. My name is Matthew Pomy. I'm an attorney in our Pittsburgh office. I'm joined today by Scott Best from our Philadelphia office and Shayna Wolin, who's also in our Pittsburgh office. We're going to be talking about reviving your deceased accounts today, focusing on a practical framework for deceased account collections and talking through a way to essentially think through those decisions. We also have a beer here today from Grist House Brewing in Millvale, Pennsylvania, one of my favorite breweries in the Pittsburgh area. It's just right north of Pittsburgh. We have a Camp Slap Red today, which is a little bit of a twist on a normal IPA. It's maybe not great for your summer sipping, but you know it's a good change of pace there. Before we get started, I would like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of the webinar, a link for the recording and a copy of the presentation slides will be sent to all attendees. Also, there will be a short survey on your screen at the end of today's webinar. Please take the survey and share your feedback. We greatly appreciate hearing all of our audience opinions on our webinars, and we try to take those into account for future sessions. So first, we'll get right into it. What we're going to be talking about today is collecting on deceased accounts. We're going to first go through kind of the workflow that we see on a day-to-day basis with these sorts of accounts, and kind of talk through our decision-making process when we get these kinds of accounts across our desks. So first, Scott, can you explain, I guess, why it's so important to separate these kinds of accounts from your typical collection file?
Sure, no problem. So the basic issue with someone who's passed away and handling their accounts is that they live in a different world than normal collections. They're very deadline driven. There's times to file your claims, and if you miss that date, you're out of luck. There's nothing you can do about it. Even if you don't find out about it, the person passing away until after that deadline's passed, that's an unfortunate event, but there's nothing we can do in the interim to help that. It's highly technical, highly procedural in how you have to handle the account to get yourself paid, even if you're 100% correct on the merits, so that there is an estate, you have an account that's outstanding, there's a balance due, there's money in the estate to pay you, but you miss your deadline, you're out of luck. What also makes these difficult is in these situations, you're dealing with the family typically of someone who's lost a loved one, so there is a compassionate aspect to how you have to handle the account. You know, you can't handle the account more aggressively or in a more aggressive nature than you would. You have to understand that someone who you're trying to get payment from there's a high likelihood that they're grieving. In these instances, again, payment depends on the estate assets and priority rules. Every state has its own order of payment. Administrative fees and funeral costs are always at the top of that, including attorney and estate administrative fees for the executor or the representative. And then there's kind of a litany of how everything else gets dispersed. Sometimes you just get a percentage based on what's there. There's higher costs and longer timelines than is in your standard collection case, in that you are tied to the speed with which the estate processes. You can't force it to move any faster.
And you're going to be working with this person who's handling the financial affairs of the estate for the entire duration of the probate process.
And in some instances, it's not something they have any idea what they're doing. They don't want to incur some of those additional costs, so they're trying to do it themselves, but they don't know what the heck they're doing. Or if the person who is appointed as the administrator or the executor thinks they can do it, or it's kind of close to what they do, or they get a family friend who's an attorney who doesn't typically do this, then it can really slow down the works. And lenders can get frustrated by how slow it's moving, but there's not a lot you can really do to move the process along any quicker. But those early decisions do change the outcomes. The quicker you can learn about the estate, file the claim, all of that, the better off it is in the long run for your estate or for your claim to get paid. So in that regard, there is kind of a workflow that we've developed, or a lender should develop over time, that will allow you to get the jump on the file, which includes having continuous date of death scrubs. There are vendors out there who allow for kind of this to be run on a daily basis. You can then also have folks who do estate skip and asset searches. You have to contact the decision makers. You want to reach out to, once you are able to find out if there's an estate, even if there's not an estate, try to reach out to someone, if it's a surviving spouse, things like that, to find out, or to let them know we have a claim. You then have to file the claim to make sure that you're in line to get paid, possibly. There's no harm in filing one, even if you think there's a high likelihood you won't get paid. You want to get in line. Then comes the situation of, if your claim is rejected or denied, do you have any options at that point to force payment? What can you do in those situations? And examining your case to see, really, is it worth pursuing? If a claim is rejected, do you want to incur costs, time, effort? What's going to be gained out of doing that, which is always a factor in these instances. Someone already owes you money, they pass away. Do you want to spend good money chasing bad money to possibly not get anything anyway? Right. So all those, we'll go into that later, but there's lots of factors that go into that to make that determination of how do you want to handle this? Right.
And obviously, not every estate is going to go through the same steps. I mean, no two files are alike in a lot of ways. So, sometimes deceased accounts won't be probated. Sometimes there's no need for that on the family's end. So really, it's just a framework of trying to think about this sort of account once you have notice of the date of the death of the consumer. Now, Shayna, we talked a little bit about date of death scrubs. Can you tell us a little bit about, I guess, our experience with that sort of practice with our accounts?
So we typically scrub all the accounts that we get, and you first want to see if the person actually died, the correct date of death here, and maybe where they lived when they died. Early detection in this situation is super important because, like Scott said, probate is very heavily deadline driven. It's best practice to scrub the delinquent accounts as well, because getting ahead in general is super important to get all this information moving down the line of the workflow.
What do you do with false positives? I mean, is there any issue with like identifying a wrong individual?
Yeah, so sometimes we will have people who pass away in the same jurisdiction with the same names. There'll be families with juniors or seniors. So at that point, you want to confirm their social security, their date of birth, so to fully confirm that person.
Yeah, and I know we do have, unfortunately, the occasion where we do have a misidentified date of death, and we unfortunately file a claim in the wrong jurisdiction. It's usually a pretty easy thing to verify with the state council, and then you just real quick withdraw that claim and move on.
And related to the date of death scrubs, is there a recommendation you have as far as how frequently you should run those scrubs? Should it be, is daily overdoing it? Is it a weekly, monthly situation, every other? Because if you catch it in 2 months, you should still be fine to file the complaint or the claim. But is there a recommendation you have as far as how frequently do you really need to be running these?
I mean, I think every institution is going to have their own approach to that with their own risk tolerance. We typically scrub on a daily basis. If you want to scrub every 30 days, maybe that's a consideration based on your jurisdictional timeline. If you're in a jurisdiction where you have 9 months, like New Jersey, to file a claim once an estate is probated, maybe you have a little more leeway in your scrubs, and you cut down a little bit, maybe 30 days, something like that. But if you're in a particular jurisdiction that has a tight deadline, maybe you're scrubbing a little more often.
Yeah, which makes sense. Sure. You don't want to put yourself behind a timeline. Right. But you also don't want to overkill.
Yeah, because it is a cost.
There is a cost associated with it. These search sites, while they're helpful, are not free.
For sure, yeah. So you want to weigh that with what your needs are as a creditor in your particular jurisdiction. Now, once you actually have a date of death reported, what's the next step for a creditor?
Yeah, so after the death is reported, you want to check whether or not an estate has been opened and whether there is a responsible individual. At this point, there may be some waiting period, but this is not the time for the creditor to sit back and wait. You really want to get ahead and check for assets. We use a vendor called Accurant, which is through LexisNexis, and this helps us search public records for assets. At this point, you'll want to search through court filings and see where public records are available to see where assets can be found. And also at this point, you are dealing with a loved one or someone who has lost a loved one in this situation. So being compassionate and professional is super critical here. And also to create a relationship with the estate moving along, to know that you're there for them. You also want to create that relationship to build a rapport with the estate.
Yeah, and sometimes that puts us in an odd situation where we actually end up knowing more about the estate than the person handling the affairs. I know just recently we had a situation where an estate had real estate with a reverse mortgage in the estate. And my initial conversation with the with the attorney for the estate, they didn't even know about the reverse mortgage. I was the one telling them about that, and that's because we went through the extra step to pull the deed from the public records. So, it's a really good point. You don't want to waste this time early on. You want to, start building the rapport with the estate and building your own idea of the financial situation of the deceased individual.
Yeah, and similarly, you run into situations where you have a person who typically is a surviving spouse who didn't ever handle the financial aspects of things, and the person dies, the husband or wife dies, and then they start getting letters from all kinds of credit card companies or mortgage companies, and they had no idea those things even existed. Right. They're shocked to find out. Like they may know that the husband had a bunch of rental properties, but they have no idea that in kind of keeping those properties, he also had credit cards that had balances due, and how to handle that. Yeah. And they just say, I didn't even know. I've seen it happen frequently, where people just say, I have no idea that was even there. I didn't know he had these accounts or she had these accounts. He always handled it. I just thought it was taken care of. Not that they don't have the funds to pay it. It was just they didn't know. Yeah. They just had no idea.
And that's a great point, because you're dealing with not only someone who's grieving potentially, but someone who's finding out about all of these other financial affairs that they had no dealings with before.
And who really don't want to be dealing with it. Right. I've heard that more times, that they just get frustrated. They don't know who to talk to. They're mentally all messed up because of who they lost, and then now they're trying to deal with things they had no idea even existed, and they don't know where to begin in handling them. So that's where working with them, understanding where they're coming from, like you just can't hammer them and say, there's a bill, you have money to pay, and now pay the money. That doesn't work.
When it's maybe the first time they're hearing about the bill.
Yeah, you have to take kind of a not hands off, but a more gentle approach in dealing. Now, some people are hard to deal with, and if they're obstinate or whatever it might be, that's a different situation. But but you want to, most people in these situations don't want to be dealing with this, and they just want to get rid of it as soon as they can.
Yeah. And I think that brings us right into, once you are contacting someone who is in charge, someone who's identified themselves as the person managing the financial affairs of the estate, that seems like where the rubber meets the road, and we kind of really start working with them. So can you talk a little bit about the approach once we have someone to talk to?
Yeah, so once you have someone to speak to, typically when there's a will, they'll be the executor of the will, and then if there's no will, they're administrator of the estate. So at this point, the fiduciary steps into the place of the decedent. And at this point, you'll want to collect as much information as possible. But like you guys said, again, you really want to be compassionate. This is a situation that's tough for them. They don't know what's going on. But it is super important to still collect as much information as possible here. And this is also the person that you're going to be dealing with when you're negotiating some claims or speaking to throughout this process as well.
And it's also important to advise these people, because they're a third party essentially, that they're not personally liable on the debt. Mm-hmm. So when you're getting these people on the phone, you're telling them, hey, you don't have to use individual assets for this. You're not personally liable. But then we're also asking for them to use estate assets to pay for the claim. So it's a very complicated thing to try to explain to someone who's wearing potentially multiple hats, trying to resolve these accounts.
Definitely does happen where people think they're going to have to pay because they're either the administrator or the executor, that they're personally going to have to pay this. And I don't have that kind of money. We understand that it's outside of something unusual happening. It's not your debt to pay.
And I actually think we have a question here right now. Shayna, can you take a look at this one?
Yeah. Yeah, so what if we were contacted by family members who say the only account is a small bank account and they want to avoid probate altogether?
Yeah, I mean that's definitely a jurisdictional specific question. Every jurisdiction is going to have its own procedures for a small account, or for a small estate. In particular, Pennsylvania, where I mainly practice, there is a statute that allows for a next of kin to receive a distribution from a deposit account if they've paid the funeral bill and they can show their next of kin. So that's a little bit of a workaround through the probate process. And I know, I think in January, the limit on that distribution went up from $10,000 to $20,000. So it's definitely on top of mind for a lot of financial institutions. So as long as that transaction is happening after the effective date of that statute, which I think is late January, you should be fine going forward with that distribution. And allowing the family member to avoid probate in that way. But you definitely want to be mindful of the jurisdictional processes of the different places, because that statute doesn't exist everywhere. Once we have someone who is handling the financial affairs of the estate, there's an estate open, what's the next step for a creditor?
Yeah, so if probate is open, the creditor will then file the claim with the estate. Here again, you really want to be conscious of the local rules because every jurisdiction is different. And also deadlines and form requirements are super important here. This claim will then put the estate and the court on notice. So here you just want to make sure you're getting all your documents, your forms, looking out for deadlines, really being conscious of those things.
And really the main concern for creditors is when there's not probate, what to do then. In most jurisdictions, there are ways where a creditor can open an estate on behalf of the creditor and essentially present the claim to themselves. That does get pricey, so you want to make sure that there's some assets that you verified in this deceased individual's name before proceeding in that way. But if you're coming up close to your local deadline and there's still no estate open, it's probably time to start thinking about whether or not it's feasible to open an estate yourself and present the claim in that way. And I actually think we have another question here that I'll take this one. Shayna, what documents do you typically require to be originals when an estate is open?
Yeah, that's a really good question because I know sometimes these documents are very hard to gather, especially the original ones. So you really don't need original documents at all here. Just copies, we generally tell people, are good. And that works to help get the claim going and the process going along.
Yeah, I know in Pennsylvania it's really difficult to get a death certificate, so we don't typically require those to be originals. A copy is going to be fine there. And same for letters of administration when you're appointing a fiduciary. It's going to be public record documents, so really a copy is fine in my experience for those sorts of things.
And now, Matt, circling back to something you had said earlier about forcing an estate open, what is the process from a creditor's perspective? Like, I know in Ohio, it has a super short window to file anything. In other states like New Jersey, it's 9 months, which isn't short, but it's not long either. Sure. What do you have to do in those situations where the executor administrator is really dragging their feet in filing anything for probate? You know there's assets there. What do you have to do in those situations?
That's a really great question. We get this question all the time. And it's unfortunately jurisdiction specific, but particularly in Ohio, because the deadline's so short, is where we have most of our experience. And essentially the process is we have an attorney from our office who's local to, at least close to local to the county where the estate's going to be open. We have them appointed as the special administrator of the estate, and then a separate attorney represent them as the counsel for the estate. And then that claim can be presented to the special administrator in a timely manner. Because in particular, Ohio, you have to present claims to an appointed fiduciary. You can't just send out a claim willy-nilly. You've got to have somebody who's been appointed by the court.
You can't just send it to the surviving spouse and saying, I sent it, that was appropriate.
Right.
There's an actual court-appointed process to get the right person appointed to
Right.
then notify.
Yeah, and it's not always quick. So sometimes you've got to do that well before the 6-month deadline because it might take a couple of weeks to actually get someone physically appointed.
And does the order have to be entered before that?
Yeah.
So the quicker you act in those situations, you don't want to incur the cost if not necessary, but you don't want to delay until it's a week before the 6 months because you're not going to get a hearing, generally speaking, in that time frame.
Yeah, so it's a little bit of a catch-22 because you get into a situation where we don't necessarily want to be administering an estate as a creditor because we'd much rather have the family come in and do that. But if they're dragging their feet potentially intentionally to avoid this claim, we're going to have to step in at a certain point and protect our claim.
Force their hand a little bit.
Right, yeah, force their hand, and then eventually, most of the time, the idea is once we present our claim, we withdraw as counsel for the estate and as the special administrator, and then the family members can come in and start administering the estate in earnest.
And going back to what Shayna was saying earlier about trying to determine assets, that would be something you wouldn't do this on a case where you don't believe there's any potential payment. It's only based on your review of assets and where you think their assets are or amounts are. That's where you would then pursue it.
Absolutely. In my general rule is that there's no real property in the name of the deceased party, it's likely not worth it to go through a special administration on your own because you do have that maybe slight likelihood that if no family member is available to step in as an administrator, the court may look to you as a creditor to fully administer this estate, which is not a position creditors want to be in.
Yeah, they don't want to be doing that.
No, yeah, and especially if there's not significant assets. So that's where you really want to make sure you do the upfront work to identify anything possible that may be available in the estate for collections. So once we have a claim filed is the fun part. So obviously if the estate is going to acknowledge the claim and just pay it, it's going to be done right away. But that doesn't always happen. So if that doesn't go to plan, what's the next step for a creditor?
Yeah, so at this point there can often be a lot of rejections, and typically that's a negotiation tactic for people who don't want to pay out those claims. And at this point, this is when the file really turns into a normal contested litigated file, and this is where you are spending real legal dollars here to move this file along, and also where your initial research really pays off to see if you really want to proceed with this file as well. So yeah, a lot of people will reject to negotiate here, but
yeah, it's a really frustrating thing for me in particular because in my view an estate fiduciary owes just as much of a duty to the heirs as they do to creditors. I mean, they're supposed to be going through the process according to the statute, and here we have a lot of estate counsel who's just across the board rejecting all claims no matter what, and essentially forcing creditors into this kind of litigation.
And what's their basis for the rejection or objection? Is it just they do it to everyone, and when you see Attorney X's name come through, well, he or she's going to reject everything?
Yep, we see that all the time, especially in Ohio, where there's such a tight deadline on the statute. They'll reject everything across the board. They don't even have to give a reason. They just file what's called a notice of rejection, and then that puts us into a situation where we have to file a complaint. Now, some jurisdictions, the next step after a rejection, the court schedules a hearing. So that may be a little more cost-effective for creditors. Because paying to go just show up at a hearing that may take 15 minutes is a lot different from filing a separate action against the fiduciary that may lock you into more litigation. So definitely want to be sure you're understanding the differences in your jurisdictions and what it's going to mean to proceed after a claim is rejected, because those are very different cost-effectiveness analysis. Speaking of that, when you have this cost-benefit analysis, what are the creditor's options once a claim is rejected?
Yeah, typically when a claim is rejected, the next step will either be a deadline for the creditor to file a request. So this usually happens via petition or a complaint, or the court will schedule a hearing on the merits of that claim. So most jurisdictions are going to want a witness at this hearing, but some will allow documents in regardless. Luckily, many probate courts also widely approve requests to appear on Zoom or phone, which is very convenient in this matter. But in jurisdictions where the next step after rejection is a hearing, it may be more cost effective than in jurisdictions where creditors are required to file separate lawsuits like you were saying before.
Perfect. So when you're deciding as a creditor what to do after a rejection, or even what to do once you get a notice of a date of death, there are essentially some sliding scales that, at least in my practice, we try to use. First, can a claim be timely filed? Is there are there any verified probate assets that you've identified in your early searches? Are there other timely claims that you filed? Are the expenses of the estate reasonable? And what secures your underlying debt? Is it an unsecured claim? Is it a judgment lien, and whatnot? So the first factor, at least that I focus on, is can a claim be timely filed? And in my opinion, if you can file a timely claim, you've got to file it. You got to put the court and the estate on notice and get your supporting documents out there just to advise everybody of what's going on. Like you were talking about before, sometimes these people don't know what the estate encompasses. So you've got to tell them.
You can't get paid if you don't let them know.
Exactly. So that's the first thing. So anytime you can file a timely claim, definitely do that. One thing that we do see sometimes is there are different jurisdictions that have different presentment standards. So some jurisdictions you have to formally file a claim with the court, and that's pretty easy to show whether you did or not. But some jurisdictions you can essentially just send a letter or a statement to a party who's deciding these things, and that may serve as essentially an informal claim. So if you see that you're close to a deadline or potentially past a deadline, you can do a little bit more of a second level analysis to see if maybe you've sent a statement in the last 6 months after death, and that got to the appointed fiduciary. You can make the argument that that is essentially presenting a claim. Yeah. So there's some ways to kind of finagle that kind of argument if you're close.
Yeah, you complied in spirit.
Exactly.
Not in technical form, but you in spirit complied with what you were supposed to do.
Right.
Whether or not that works,
yeah,
depends on the judge.
Yeah, it's an argument though. So you may be able to save some arguments on your claim if you do a little bit more digging there. Another big factor that we've been hammering on today is verified probate assets. Particularly, I want to emphasize the priority waterfall, and you really want to be mindful of how assets are going to eventually be distributed. Like you mentioned before, administrative claims get paid first. That's going to be the funeral bill. That's attorney's fees, obviously. Any kind of reasonable expense that the estate needed to incur to further the administration.
How does the court view reasonable?
That's an interesting question. It definitely varies, and it's going to come down to what that particular estate is doing. So if one, and we'll get into this a little bit later, if it's an insolvent estate, a court's not going to allow ridiculous fees from an attorney who's not doing a whole lot with no assets. Similarly, if you have an heir who's taking possession of an asset and they're trying to, say, put a car payment on an estate administration expense when they're the one receiving the car, that's not going to typically be allowed.
Yeah.
So that's kind of in some jurisdictions actually require fee applications from fiduciaries and from attorneys. Some jurisdictions it's just going to be sort of a no-look analysis. So if you're under a certain percentage of the state assets, the courts aren't really going to question it. But if you're over that, that's when they're going to want to see a formal accounting or something along those lines.
Yeah, and going back to what we had talked about earlier with regard to, especially in married situations where there's a bill only in one of their names, but you have verifiable assets. Unfortunately, in most states, you're not able to get to those, depending on how the assets are titled.
Right.
They're going to pass the surviving spouse, so there's no estate raised, so there's no necessarily not an obligation on behalf of the surviving spouse to make payment on those bills, even though they were jointly both benefited from it in some fashion.
Mm-hmm.
But there's not a lot, because of the way that married assets are protected, there's not a whole lot that is done in those situations. However, some will still pay. It's
Right.
just you can't really force them to.
Exactly. And that's a great point because we are talking about particularly probate assets. So it's only assets that are going through the probate process. In a situation with a surviving spouse, those are going to transfer by operation of law outside of probate. So the creditor waterfall won't really come into play. And hopefully you've identified those assets as being jointly held early on in the process and aren't surprised when you're potentially expecting some asset to be a part of the estate, and then lo and behold, it was actually a jointly held asset or transfer on death designation.
Because I know that does come up where creditors say, well, I know that the surviving spouse has an asset, or there's money in the house, there's equity in the house to pay off the guarantee on the student loan or whatever it may be.
Yeah.
But because it passes, there's nothing you can do to force their hand to pay. It's especially if the debt is only against one of the individuals. If both are on the account, it's a different situation.
Sure. Yeah.
But if it's only one and the surviving spouse, it wasn't on the account, there's nothing you can do.
And similarly, there's exemptions in a lot of different jurisdictions for surviving spouses, minor children, things like that, that exempt certain assets or certain amount of assets from a probate estate. In Pennsylvania, it's a pretty low one. It's $3,500 for a surviving spouse. In Ohio, it's significant. It's $40,000 in 2 cars. So if you have a surviving spouse in Ohio, the first $40,000 in 2 cars are out of the estate.
Automatically.
Yeah, automatically. Those shouldn't be calculated in terms of what you think you're going to be collecting through the probate process. Yeah. So yeah, the next thing that we think about is whether or not there are other timely claims filed. This is somewhat of a counterintuitive analysis, particularly because of the priority waterfall and how estate assets are distributed. It really becomes relevant what other creditors are actually timely filing claims and who you're competing with essentially as a creditor for other claims. So because in an insolvent situation, you're going to be sharing the distribution with the other creditors in your same class. So if you're an unsecured creditor, maybe a credit card, something like that, you're going to be getting a proportional share of whatever assets are going to other unsecured creditors. So one thing I always like to do is try to see what other claims have been filed in a timely way and aren't being rejected or are being allowed, and that's going to set the standard of what we should expect to recover. Similarly, with rejected claims, if you actually litigate a rejected claim and say the estate is rejecting all claims across the board, and we're the only creditor who litigated that rejection to an allowed claim, now we're the only creditor in that class, and we don't have to share those distributions with anybody. So that's something to consider. If you're the only creditor, you may be in a position to have some leverage there. So going back to reasonable estate expenses, like we talked about briefly, you want to just do a pass at those expenses to make sure that they're reasonable, and that's going to be based on the status of each particular estate. So use the information that you got early on in the process to think about whether or not these expenses are reasonable. I had one estate that was completely insolvent, and the attorney for the estate claimed $9,000 in fees. Based on all I could tell from the estate, all he did was open and shut it. He didn't show up to any hearings. There were no assets in the estate, but for some reason he thought he was entitled to $9,000. And so obviously we contested that, and it freed up a little bit more money to be distributed through the estate process. Similarly, if you have an heir who's taking over a mortgage on a house and is taking that house and trying to put 9 months of mortgage payments as an administrative claim to keep that estate asset going, 9 months is a little long. If you're 1 or 2 months, the court might be okay with, but 9 months is a little much. So be sure to be mindful of that. Also, be mindful that that litigation potentially is going to be further expense that the estate's going to have to incur. So you may be diluting those funds even more if you take issue with those. But it is an avenue to potentially question.
It's based on what you're seeing, you know,
Right.
if you don't want to incur the additional cost to fight it, or the attorney's fees to fight the argument of the reasonableness, then you're going to lose what you're arguing. And so it's the money's going out the door one way or the other.
Right.
It's just how is it, unless it's just ridiculous. And then in those instances, you're like the $9,000 to open and close an estate. Then you're going to push on that.
Yeah. Lastly, is you want to look at what sort of leverage you have in your underlying debt. In particular, if there's a judgment lien or a mortgage lien, that's going to be a significant amount of leverage for a creditor. It may not make sense to put more money into probate litigation when you have other remedies under the lien. In particular, with a mortgage, you file a claim on a mortgage and an estate. If the estate rejects that claim, you may make the decision to not pursue the litigation in probate and just move forward with a foreclosure outside of probate. So it's important to understand that the lien rights available to secured creditors remain after the date of death of the consumer, and keep that in mind when deciding what to do.
So your judgment lien or your mortgage doesn't get wiped away just because someone passes away.
Exactly.
Similar to a bankruptcy situation.
Right. So if you have a judgment lien that's attached to real property, that doesn't go away just because the person passed away.
Okay.
And there's even more protections for mortgages. Many jurisdictions, PA being one of them, exempts mortgage claims from the deadline process. So you have essentially the entire time of the probate being open to file a mortgage claim, because that's a big asset that they want to make sure that creditors don't miss out on just on a technicality.
Yeah. Especially if maybe after the fact it's still getting paid, they might not even know that the person's going back to point one of filing for date of death.
Right.
Mortgage company might not always know that the person's even deceased.
Yeah, because if the surviving spouse is living in the property, they just pay the bills as they come in.
Yeah.
They may not know for months and months and months. So yeah, that's definitely a good point. And I think we have another question, Scott.
Okay, so this is a question for you, Matt. What is a creditor's ability to challenge or collect credit card accounts that were used after the date of death for random expenses or expenses related to funeral or paying an attorney or something along those lines? Does a creditor have any ability to challenge in those instances?
Absolutely. So I think we've got two different scenarios. One is the scenario you brought up where the surviving spouse or family member doesn't necessarily know the obligations that the decedent has, and maybe using a card that they didn't even know they were only an authorized user on. And so they may continue to make everyday purchases and continue to make those payments, and that's a problem. It's technically fraud, and a creditor is able to collect those charges, but it's not necessarily egregious. The other side of that coin, though, are people who know that they are not on the card and are not intending to repay what they are spending. We see a lot of people putting funeral bills on credit cards after the date of the passing of the account holder. That is not right, and we've had success having those paid as administrative claims and essentially splitting that out from the unsecured claim. Because in every jurisdiction, the funeral bill is going to be very protected, and judges are going to be.
It's always one of the top things that gets paid is the funeral bill.
Exactly, and so judges are going to be very sensitive to that. So if you see that kind of activity, it's not technically a claim of the estate. It's technically a claim against the person who actually incurred those charges. So it may take a little bit more digging to build the evidence against that person to further the collection.
But you could pursue them if necessary.
You absolutely could.
Which we have done. Yeah. That you find out that the nephew either got the card or somehow and then used it for the week after the funeral, buying TVs and all sorts of things unrelated to the underlying estate. It's not restricted to estate administration. They're using it all over the place. We just need to get the information, which can take a little time to compile it, but we can then pursue.
And that's part
recovery.
and that's part of talking to family members after the passing and getting that information, because something tells me other family members are not going to like that the nephew is charging up grandma's card. So you get that information as best you can, and then make the decision going forward.
That may be one of those situations where your compassion level goes down a little
It
bit.
may change a little bit there.
You might be a little bit more forceful in saying you knew you did something wrong here.
Right. Yeah, I think that makes a lot of
And
sense.
you knew you shouldn't have done that.
Sure, and now pay for your weekend away.
Yeah. Yeah, because we knew that person wasn't going anywhere.
Right.
So
Yeah, exactly.
there's no reason to buy a plane ticket after the fact.
No. But yeah, so we've talked through our decision-making process. Scott, can you talk a little bit about coalescing all of this information together?
So from the outset, as we've gone over, it's very important to set up a practical framework that can be created and repeated for file after file. So the question is, can we file a timely claim? Are there any real assets to pursue, mainly property? Or to the extent an investment account or whatever. Will there be a ton of other creditors? Can you tell from a credit report or what else has been filed? Are there going to be a lot of other claims or excessive expenses given situations that are out there? What kind of leverage do we have? Do we have a mortgaged property? Do we have a judgment lien against the real estate? And finally, do the economics make sense? Does it make sense for the creditor or the lender to incur fees paying us, fees having to do A, B, or C to pursue an $800 account or a $1,000 account? If it's $9,000, it's different, but does it make sense to continue to spend money? Yes, they owe it. You would like your claim paid, but depending on how your attorney, what their fee structure is, does it make sense to pursue it?
For sure. So yeah, I think we have a good practical takeaways here. Obviously get involved early in the process, gather as much information as you can so you can make better decisions down the line, and not understand that not every deceased account should be pursued. It should be a business decision that's made through some sort of practical framework to know whether or not you should be pursuing these.
And we shouldn't make the assumption that the estate will do the right thing in all instances. Yeah. They don't want folks necessarily in their heads, and sometimes that's my inheritance. I'm not paying. I'm going to do everything I can to protect it. So there is always that is an aspect that you have to deal with.
Yeah, and that's why you got to go through this formal process sometimes to make them go through the correct way. So we'll wrap up there. Thank you all for attending the webinar. For all those registered, you're automatically entered to win a special What's on Tap giveaway. If you submitted a question that we didn't get a chance to answer during the webinar, we apologize. We'll get back to you on the question directly shortly after. Please note that the next What's on Tap webinar is going to be coming at you September 17th, and that's going to be episode 13, Post-Judgment Rights and Remedies, How to Monetize Your Judgment. And I want to thank Shayna and Scott for talking with me today on deceased accounts. So we'd love to hear from you. Feel free to reach out to any one of us. There's a contact. All of our contact information is on a slide that's going to be presented to you. Also, if you're interested in any previous What's on Tap episodes or any of our other webinar series, please visit our webinar library in the link slide. Lastly, be sure to follow us on our social platforms for weekly content.